wanted to go see a little Brian, or you can hang on to it. It really
No.
doesn't matter. Are you? I like your suit. Very much. You have Lonnie Richardson, I'm woodwhack, so I get woodwick and loudwick and all sorts of stuff.
All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. Call your name. Please say present or here. Raise your hand so that I can make sure that I mark you down as being present. And then counsel, as you know, once I call the docket, if you want to form a line over here for anyone that's ready, then I'll call you up as I see you line up. Gregory Beaver. Thank you, sir. Tammy Caldwell. Taylor Davidson. Taylor Leon Davidson. Christian Grindel. Joseph Holloway. Thank you, Mr. Schmidt. Brian Mason. Thank you, sir. Bryan Vasquez Capistrano. Jamie Johnson. Thank you, Mr. Tyra. And just for the record, because it's on my docket, CR 2295, Heath Earwood. I believe the state tendered a motion to dismiss. Court granted that, signed that on May 11th, yesterday. So that case has been dismissed. Will be removed from them. Cornelio Reyes. Michael De La Rosa. Harold Dunn. Jackie Elliott. Lonnie Richardson. Got a note that Mr. Richardson called, said that he is running late, stuck in traffic. Is that right, Mr. Dunn? Mr. Dunn. Is Mr. Richardson here yet? I called his name. I know he called in to the court and indicated that he was running late.
I spoke with him yesterday and said he would be.
Okay.
Come back to the judge.
Yes, sir. Shane Baronette. Thank you, Mr. Mims. Keisha Kaufman. Keisha Kaufman here. Miss Abraham, did we inform Miss Kaufman that the case? Okay. Keisha Darnell Kaufman. Nash Fuller. Okay. He was the one you were trying to waive. That's correct. Okay. And that was going to sign with Carl. Okay. Kiana Walker. Shanna Dixon. Rashana Dixon. That one's been dismissed. Thank you, Mr. White.
Yeah.
Christopher Gango. Jose Herrera. It's at 10 o'clock. I just didn't know if he was here. Is he here? Dina? Okay. And then Mr. Howe is at 11. Mr. Reisner would be 11:30. Is there anyone who's present in the courtroom and I've not called your name? All right, counsel, do we have anyone that's ready? Mr. White, you ready? Ready on Mr. Gango?
Yes, sir.
Christopher Gango, CR 2221. You'll come up to the middle podium, please, sir. All right, Mr. Gango is set for pretrial.
Yes, sir. Last time we were here, I had filed a motion for discovery of some blood evidence. Ms. Heisel said that she would get right on that. She did. She emailed the DPS lab. They emailed her back. She sent me a copy of the email. They said that they would get that and provide it to her, as I recall, as quickly as they could. They still have not provided it to her according to Ms. Heisel, so I'm going to ask the court what they say.
Any objection?
No, Your Honor, that's all correct.
All right, we'll reset it another 30 days and see if we get that. Did they give you any kind of time estimation in the email?
No, Your Honor, they asked for clarification on what was being requested. We responded, we conferred and responded, and I haven't heard from them since.
Mr. White, remind me, you available either June 14th or 16th?
June 14th, I believe. No, June 16th, I think is what we decided.
16th?
Yes, sir.
All right, Mr. Gango, the court will set you for an additional pretrial on June 16th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Is that all you have, Mr. White? So this afternoon? Thank you, sir. You ready, sir? Remind me your name? Burns, yes. Yes. Harold Wilmer Dunn, Jr., CR 2216. Come on up, sir. Come up to this middle podium. All right, Mr. Dunn is set for pretrial. Mr. Burns, do you have any contested pretrial issues that you need to take up with the court?
At this time, no, Your Honor, that the issue right now is there were some CDs that I still have not received from the district attorney. And I'm going to pick those up. That's when I'm finished here today. Initially, they were going to mail them to me, but I don't know, somehow it just kind of got miscommunication or something. So I'll pick those up, and I guess what we'd like is another pretrial.
State any objection, any issues with the discovery?
Your Honor, I believe that they are ready for pickup.
Based on our discussions, I believe that there was a miscommunication on how we were going to get it to him. So we will, I think it's prepared. We just need to make sure he has access to it.
I'll go down there as soon as I'm finished here.
All right, court will reset Mr. Dunn for pretrial. Are you available on either June 14th or 16th?
June 14th would be best day.
All right, Mr. Dunn, you're reset until June 14th at 9 a.m. Once you sign and get the yellow copy, you're free to go. Shane Baronette, CR 2261.
Morning, y'all.
Good morning, Mr. Mims. How are you doing, sir?
Good, well.
Mr. Baronette, set for pretrial.
Hey, except for pretrial, Your Honor, I'm gonna ask one more time. We've had issues with the display over Discovery. I went by the DA's office, picked this up this morning. There's also apparently a statement that was taken, a video statement from Mr. Baronette when he was arrested. We're not able to get that. I think that's somewhere in the mix too. So I need a reset on the pretrial after schedule order too. I have some deadlines in there, so we get a reset on that. 30 days or so now. We have our annual Rusty Duncan seminar. I know you set the other case for June 14th. Our seminar starts the next day down in San Antonio. That'd be a conflict for me if something was set up a little longer.
What about June 2nd?
Judge, the state is gonna actually request that we push this out a little further. One of the videos was a jailhouse interview of Mr. Baronette, and we actually had the video for the wrong defendant, which was brought to our attention. So we actually don't have that from the sheriff's office. Deputy McLeish has graciously volunteered to help us find that. So I don't know that we can obtain that in our office and have the copies made and get it to him and have it reviewed before the second.
The video we had was some other person that, I don't know who that was. But
What about July 5th or 7th? July 5th or 7th?
I think that was,
Which one,
I think the fifth. Let me look, could I look?
please?
Let's say, July the fifth,
5th or 7th. I've got both of those available.
but the seventh.
7th?
Yes, sir.
All right, court sets Mr. Baronette for pretrial on July 7th at 9 a.m. Once you sign your notice of appearance, get the yellow copy, you're free to go.
Excuse me, then, Your Honor. Excuse me.
Yes, you're excused. Thank you, Mr. Vince. Mr. Bogan, you ready?
Yes, sir.
Michael De La Rosa, CR 2215, CR 2264. Show that Mr. De La Rosa is set for pretrial on the failure to comply. Well, actually, they're both failure to comply. The earlier case, 15 is set for pretrial, and the later is set, 64 is set for arraignment. Have you
Yes.
gone over the indictment in the 64 case?
The state has given me a copy. I haven't spent a whole bunch of time looking at it, but I have reviewed it. I am prepared to enter a plea of not guilty on my client's behalf. Given that I just found out about this indictment and I'm just sort of running a bit behind, I would request a second pretrial setting. And if,
Is his name spelled correctly in the indictment?
yes,
All right, he understands what he's charged with.
yes, he does.
All right, the court will find that Mr. De La Rosa has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record, and I will set both cases to run concurrently on pretrial. Are you available June 14th or 16th?
I am actually scheduled for trial. Could I set this? I was listening to the other dates. Is July 7th an acceptable pretrial date? I have no conflict on that date.
Any objection from the state?
No, Your
All right, court will set Mr. De La Rosa for pretrial on July 7th. That will be at 9 a.m. Mr. De La Rosa, once you sign the notice of appearance and get the yellow copy, you're free to go.
Yes, sir. Yes, yes, ma'am.
Get his signatures. Yeah.
Is that all you have, Mr. Bogan?
That is it. Thank you.
You're welcome. Mr. Tyler, are you ready? Ms. Johnson? All right, CR 21295, Jamie Johnson. All right, we were set for status today. I'm not sure can't remember what the status was about, but
Your Honor, the state filed a motion regarding my client's bond. I filed a response early this morning. I don't know if the court's gotten that through e-file yet. I emailed a copy of that to the state. If the court doesn't have that or can't access that, I don't have a paper copy with me, but I can email the court if you want to look that up or review our response or to that, or I can address what we.
yeah, if you'll just argue it, but no, I don't check e-file before court, and it takes some time to get from the clerk's office to my coordinator to me. So yeah, if you want to address it, I've reviewed the state's motion. I believe it's on the allegation that Ms. Johnson has tested positive for THC or marijuana on pretrial release. Is that correct?
That's the allegation, yes.
Okay. Is that the only thing that we were set for today?
Yes.
Dave, do you want to argue your motion?
Yes, Your Honor. Let me pull up my motion. Your Honor, the summary of the state's motion is that on looks like Monday of this week, the state received notification from the pretrial release officer, Jarvis Crawford, for this cause, that he had a positive UA that had been tested on the 26th day of April, but had come back from the lab as confirmed positive. The state believes that this is a violation of her pretrial release conditions and asked to hold her bond insufficient for that reason.
Is the state going to call Mr. Crawford at all?
Your Honor, if we could take up this motion in 20 minutes, I believe we could get Mr. Crawford here.
Any objection, Mr. Tyra?
No, Judge, I've got an 11 o'clock in Upshur County, so as soon as we can get to that, I would appreciate
As soon
that.
as Mr. Crawford gets here, then we'll do that, and I'll try to take this time to get the clerks to forward me your response. That way I can read that and then also listen to your argument.
Okay, thank you, Judge.
Chester, are you ready? You ready on Jackie Elliott?
Yes.
Jackie Elliott, CR 21323. Is this a plea today?
It is not. We are just being set or needing to be set on the jury trial list.
All right. All right, so the court had this set for docket call, possible plea, and so it's my understanding that the plea agreements have been discussed, that either the state's not making a plea offer or Miss Elliott's rejecting plea offers and
There-
requesting to be placed on the jury trial docket.
Correct, Judge. There was a plea offer made. There was a time offer as well as an alternative probation offer. Ms. Elliott has decided to not go forward with either of those options and would like to be placed on the trial list.
Okay, and can you tell me what the offers are that she's rejected so that I can notate that for the record?
Yes, it was for probation. The terms were 8 years probated for 5 with a fine of $2,500 and completion of a rehab program, as well as being on an intensive reporting program for at least the first part of it until she was released.
Assuming that was safety.
Not safe P.
We originally discussed safe P. She found a separate rehab that we had agreed to, but so we had changed that to be a separate rehab program.
And I'm assuming that there must be enhancements because I show that it's a state jail felony.
It's enhanced to, there are 2 paragraphs for, this is allegedly a 3rd degree, Judge.
Okay, thank you. Go, and I'm sorry, Ms. Chester, go ahead. What was the time offer?
Time offer was, I think it was 3 years TDC.
I believe that's correct, Judge. For TDC and the $2,500 for TDC.
All right, you've discussed both of these offers with Ms. Elliott, and she's rejecting these today, and she understands that the rejection of these offers and being set for jury trial means that the court's not going to accept a plea later. So we get to the Friday before a Monday jury trial, and she decides she wants to go on probation. The court's going to reject that. The court's going to put her to trial because that's what she's asked for.
I explained that to her. Yes,
She
Judge.
understands that?
Yes, sir.
All right, Ms. Elliott, the court will place you on the jury selection docket beginning Monday, June 6th. So you'll need to appear here in the courthouse downstairs at 8:30. Remember, my staff will be down there to assist you with paperwork. Ms. Chester is not going to be required to be here until your case is reached for trial. Okay? So you'll appear, they'll assist you with the paperwork, to give you your next date. And you'll continue to do that until your case is reached for trial.
Yes, sir. Thank you very much.
No. I bring the stakes. That's fine. You're fine.
I'm free to go off, sir.
Yes, you're free to go.
Thank you very much.
That's all I have, Judge, maybe.
Yes, thank you, Chester. They sure did. So. She's not in there right now. I'll call someone else until she gets back.
That one's back there. Yes. Anthony Maris. Yeah. No, Shackelford is.
Wait for the OCA interpreter at 9:30, so.
Good morning, Your Honor.
Good morning, Maria. How are you?
I'm doing very well, sir. Thank you. May, may I quickly introduce myself to the defendant, Your Honor?
Mr. Schmidt, I'm gonna need you up here so that Ms. Phillips can hear you through this. Otherwise, you don't pick up that microphone. Can I hear you? Are you on the Spanish channel, Patty?
Yes, sir.
And make sure his inline microphone's not muted on his device. Click that little button to make sure that that's off. Yeah, yes, ma'am, I can hear you. Yes, I believe that that's necessary. Otherwise, it's going to create a sound in the courtrooms. I believe it's a setting with the laptop.
She's saying anything? I can't.
Yeah, go ahead and mute it. Go ahead and mute it back. Just let's do this. Let's unplug his. Thank you, ma'am. While we're. Yes, we're good. That's what I was going to do. I think I would have this memorized by now, but I do not. I tried to repeat it one time without looking. I don't do that anymore. All right, Ms. Villarez, if you will raise your right hand, ma'am, do you swear that you swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Thank you, ma'am. I don't know what you're saying to me. I see you pointing at me and moving your lips, but I don't know what you're saying.
You can hear now.
You can hear? Thank you, Wayne.
Okay.
Excellent. Thank you, ma'am. Okay, court calls cause number CR 22-122 and CR 22-119, State of Texas versus Bryan Vasquez Capistran. And I show that he is set for arraignment on a charge of fraudulent use or possession of identifying information, and also driving while intoxicated with an open container. The court has accepted his application for the appointment of indigent counsel. The court finds him to be indigent on this date and has appointed the Honorable Richard Schmidt as his attorney. And Mr. Schmidt is present in court today. Mr. Schmidt, are you ready for arraignment?
Judge, I can tell you that I've received copies of the information and the indictment in these causes. Briefly communicated with Mr. Capistran. His English is so limited that I am obviously not certain whether or not he understands what he's charged with, or whether or not his name's spelled correctly. Normally we wait for him reading, but in this particular case, I'm not certain that that's a wise idea.
Okay, so we'll go through that. Do you want the state to read the indictment, and we can ask him if his name's spelled correctly?
Actually, I think that if we have the interpreter on hand, Judge, I can approach the defendant and ask him if his name's spelled correctly and he understands his charge. I did get an answer from him when I asked those questions, but I just want to make certain that I got the answer I thought I did. And in that case, we wait for him reading. I don't think it would be helpful. We'd have to translate both of the documents.
Okay, and I'll tell you what, let me pull up this case and then I'll have it displayed on the screen, and maybe that will help. Ma'am? Yes, ma'am. Yes, ma'am. He now understands that. All right, so Mr. Schmidt, what I'm going to do is try to display the DWI information. Mr. Interpreter, can you ask Mr. Vasquez if his name appears to be spelled correctly in the body of this document, in the paragraphs titled complaint and also information?
Sí. Sí. Sí.
Do you want to ask questions?
Well, I would ask the interpreter to ask Mr. Vasquez if he understands what he's charged with in the indictment. I hope she heard.
Sí.
And Judge, at this time, based on those responses, I will enter a plea of not guilty to this.
Right, to the DWI. Okay, now I'm going to pull up the other case. Yes, he did state that not guilty, yes. All right, and I'm going to ask you, Ms. Diaz, if you will ask Mr. Vasquez if his name appears to be spelled correctly in this document, which is his other charge, his felony charge of fraudulent use of identifying information. It's on my screen. Let me try it again.
Donde dice es que lleva una A, ¿no? Entre la B y la R, ahí sigue la A, dice Bryan. El Bryan. A. Sí.
Bryan, like, is that correct? Bryan?
Sí. 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 Está mal.
And I would note that it's spelled incorrectly then on both the information and the indictment.
All right, and do you want to ask the interpreter to ask him if he understands what he's charged with in this indictment?
Yes, if you could, interpreter, ask Mr. Vasquez, do you understand what you're charged with in the indictment?
Sí.
In that case, Judge, I would enter a plea of not guilty at this time on his behalf and wait for formal reading as well.
Did you hear that, Ms. Interpreter? Okay. All right. The court then finds that Mr. Vasquez understands what he is charged with in both the indictment and the information, that his name is spelled incorrectly and that it should be spelled his first name, Bryan. Court will enter his plea of not guilty into the record as to each charge. Mr. Woodwhite, make sure that you have your microphones on or the interpreter's not going to be able to hear you.
Mr. Interpreter, can you hear me? State would make an oral motion to make a interlineation on both the information and the indictment to correctly reflect the defendant's name of Bryan at this time.
Any objections from the defense?
No objection.
All right, court will grant the state's motion to amend the information and the indictment to correct the spelling of the name of the defendant to reflect Bryan in each document. That's so ordered. Court will now set Mr. Vasquez for a pretrial hearing. Mr. Schmidt, look at
Back June 16th, Judge, if that's available.
And Ms. Interpreter, is there availability for an interpreter from OCA on June 16th AM? Uh, 9:30. Thank you, ma'am.
Judge, just so there's no miscommunication with Mr. Capistrano and Mr. Vasquez, I am scheduling him for 9 at the regular docket date, so we understand he needs to be here at that time, but not 9:30. It's just, we're coming back on this day. So,
Ms. Viers, does he understand that Mr. Schmidt wants him present at 9 AM so that he can meet with him and make sure that he's present for the court? But the actual hearing will not be conducted until 9:30 based on your availability.
Yes.
All right, thank you. All right, once he signs his notice of appearance, he gets his yellow copy, I believe he is free to go. All right, Ms. Viers, let me check with Mr. Manning to see if maybe his client's here early, unless you have another hearing between this one and the 10 AM. Okay, let me check with Mr. Manning real quick. If not, then if you want to, I can just have you turn off your camera and mute yourself, and I'll conduct a few hearings until they're ready. All right, thank you. Yes, ma'am, thank you. Lonnie Richardson, CR 21404. Mr. Richardson is set for pretrial today.
Yes, Your Honor. I will be picking up some discovery today as soon as media is available. I'll pick that up. We began plea negotiations today in principle. We don't have a firm offer yet, but so if we could get it passed for another docket call, I would might be able to get somewhere.
We had any issues on the discovery?
No.
All right, court will reset Mr. Richardson for docket call. You available either June 14th or 16th?
I'm available both days, Your Honor.
You prefer one over the other?
I think I'd prefer 16th.
16th. All right, court sets Mr. Richardson in both CR 21-404 and 405 for docket call on June 16th at 9 a.m. And Mr. Dahlman, make sure your client understands it's this time that I expect to hear from him on whether this will be resolved by plea agreement or bench trial or jury trial. All right, Mr. Richardson, once you sign, you get the yellow copy, you're free to go.
Thank you, Judge. Am I excused?
Yes, that all you have?
Thank you. That is.
Good to see you. All right. Mr. Tyler, are you ready?
Judge, yes, I spoke with my client, should have called and get medical records. But I think we have.
Okay, I'll recall. I'll give y'all time. I've reviewed the motion, so, I'm sorry, I've reviewed the motion and the response.
Judge, the state is going to request reset the contested docket, obviously.
Well, let's wait till she gets back.
Okay.
So that she's in here when we do this, and I'll probably we'll call it back up just a second. Let me know when she gets here, and then we'll make sure we get you out.
She should be.
Okay. That's it. Mr. Beaver, CR 2287. All right, Mr. Beaver, you've been charged by indictment with theft of property between $30,000 and $150,000, a third-degree felony, which does carry a range of punishment if convicted and sentenced to a minimum 2 years up to a maximum 10 years, and an optional fine not to exceed $10,000. Do you intend to hire an attorney to represent you in this matter?
Yes, I spoke with Bobby Mims. I'm probably going to retain him for counsel.
Okay. If I reset you and give you some time, you believe that you can have him or another attorney retained to represent you?
Yes.
Believe if I gave you until June 2nd, that would be sufficient?
That's ample time, yes.
Okay. All right, Mr. Beaver, we'll reset you until June 2nd for arraignment. We're going to have a notice of appearance for you to sign. Wait for you guys. So, Mr. Beaver, once you sign the notice of appearance, it's going to have your reset date of June 2nd at 9 a.m. After that, I need you to report over here to the pretrial release officers. I'm going to have conditions of pretrial release that you're going to sign and abide by while you're on bail. Okay. So we'll give you this notice of appearance and then you'll come back, meet with them. They'll give you some paperwork, explain to you, and then you'll be free to go. Okay. June 2nd. And arraignment. All right, Mr. Beaver, come on up and sign. Sure. Reset notice. They'll take care of you. Is Johnson back? Okay. All right, Ms. Heisel, let me recall this case just for the record. This is cause number CR 21295, State versus Jamie Johnson. We're back on the record. Is there an announcement from the parties?
Yes, Your Honor. The state is going to request a reset to the contested docket based on Mr. Tyra's response to our filing, which was filed this morning. We are going to need to address the labs issues that he presented in his response.
Do you believe May 26th would be sufficient time? It's 2 weeks.
I would think so, Your Honor.
Mr. Tyra, are you available on May 26th?
Yes, Judge, if we could do, if that's in the morning, I
It
can.
would be in the morning.
Yes, sir.
Okay. All right. Court's going to reset Ms. Johnson's case for hearing on the pretrial release motion May 26th at 9 a.m.
Thank
And once you sign the notice of appearance and get the yellow copy, you'll be free to go. Christian Grindel, CR 19177. Oh, he's a sanctions court. So. All right, Mr. Grindel, I'm going to order a drug test on you this morning. So I want you to come on back, meet with them, and then we'll see how that goes. And then after that, we'll have your sanctions court hearing. Okay, so come on back and see the probation officers. So you got on December 19th. Mr. Ashmore, are you ready?
One of mine is dismissed. I've informed the state, I believe that does count as a dismissal and an apology, and I'm owed steak dinner, just putting that on the record.
You want to get in front of the camera and say that?
Oh, yes, Judge.
And you want your web address on there?
I don't, Judge.
Yeah,
No, we're ready on Mr. Reyes, Your Honor.
Put a business card in front of
Yeah,
you. Cornelio Reyes, CR 22114. All right, Mr. Reyes is charged with a second-degree felony offense of assault of a peace officer or judge, and the court shows that this is set for arraignment. Have you had a chance to go over the indictment with your client?
Judge, I have. We've been out in the hall talking about the indictment. It's been enhanced actually to a first degree. He has confirmed his name, Cornelio Antonio Reyes, is spelled correctly. Both places in the indictment, he understands the allegations against him. He's authorized me to waive formal reading of the indictment. We talked about the punishment range, 5 to 99, $10,000 fine, and proceed forward with entering a plea of not guilty and negotiating with the state, getting the rest of our discovery. I think the paper file has been shared with us. I may have gotten the CDs when I was here, DVDs, excuse me, when I was here Tuesday. I need to double check that. If not, I'll pick them up today.
Okay. All right, the court will find that Mr. Reyes has waived the formal requirements of arraignment. The court will enter his plea of not guilty into the record. We'll set this matter for pretrial hearing. Are you available on June 14th or 16th?
Yes, sir. 14 is good.
14th. All right, Mr. Reyes, you're set to return to the court on June 14th at 9 a.m. And Mr. Reyes, one last thing, you're going to need to sign your conditions of pretrial release today. What that means is you posted bail to get out of jail. So there's going to be conditions that you're going to have to comply with to remain out of jail. Okay. And those conditions are going to be in your pretrial release conditions. And so I want you to come back here, meet with these officers. They'll give you that paperwork. Once you sign and get a copy, you'll be free to go. Okay. Mr. Manning, are you ready on anything?
Yes, sir.
Waiver arraignment? Or
We're gonna waive arraignment.
Oh.
And it's CR 22-000.
Ms. Caldwell, if you'll come forth to this middle podium, please. This is cause number CR 2290. Ms. Caldwell, you've requested a court-appointed attorney. The court has reviewed your application and finds you to be indigent at this time. The court has appointed the Honorable Jonathan Manning to represent you. Mr. Manning, have you met with your client this morning regarding her charge and gone over her indictment?
Yeah, Judge, she understands the charge of punishment. Her name is still appropriate.
All right, court will enter her plea of not guilty into the record, finds that she waives the formal requirements of arraignment. We'll set this matter for pretrial hearing June 14th or 16th, Mr. Manning, 16th? June 16th. All right, court sets Ms. Caldwell for pretrial on June 16th at 9 a.m. Ms. Caldwell, once you sign and get the yellow copy, you're free to go. Is Joseph Hollowell here? Oh, I'm sorry. Are you ready, Mr. Schuman? Okay. Okay. Brian Mason. Mr. Mason, you're charged with possession of a controlled substance in penalty group 1 between 1 grams and 4 grams, a third-degree felony, carries range of punishment of 2 years in prison up to a maximum of 10. Are you intending to hire an attorney to represent you in this matter?
Yes, sir.
Okay. All right. If I give you until June 2nd, do you believe that's sufficient time where you can hire someone?
Yes, sir.
All right. The court will reset you then for arraignment on June 2nd. That will be at 9 a.m. After you sign the notice of appearance and get the yellow copy, I want you to come back and meet with the pretrial release officers. I'm going to have conditions of pretrial release for you to sign. Okay. These are conditions that you've got to comply with in order for your bond to remain intact and out of custody during the pendency of your case. Okay.
Okay, Your Honor.
Yes. Yeah. Come back here and meet with the pretrial release department. They'll give you some paperwork, and then once they're done with you, you're free to go.
Okay. Thank you.
You're welcome. I'm sorry, that's also in cause number CR 2270. Did you have that on notice? I have it on page 2 also.
I knew I had his name
Oh, that's
listed twice,
oh,
but
it's
the
a double.
numbers
It's a double.
yes, what you just said.
It's a double. if Mr. Herrera is here. Mr. Herrera's not here. Mr. Vieras is waiting for us. Contact her. Ms. Viers, are you ready? Is this a plea today?
Judge, we were set for a plea today.
Hang on, just a second. I'm just asking. Interpreter's not set up yet. I'm just asking because that's
Yes.
all.
Judge, we were set for a plea today. We'd given Mr. Herrera a couple weeks to speak to a immigration attorney about the effects of a plea on his case. He was unable to get an appointment until today at 2 p.m. I've confirmed that appointment with the law offices of Erica Salter in Dallas, Texas. He is set for today for 2 p.m. for consultation on this matter. But prior to that, he was unable to get it. I told him that due to previous resets, we might short set him, and he is willing to do that if the court does allow him to have an additional reset to speak to immigration.
I'm sorry, Ms. Viers. I was just asking him informally. Okay, let me go ahead and swear you in just so that Mr. Herrera knows what we're doing here today. Ma'am, if you'll go ahead and identify yourself and let me administer the oath for purposes of this case. Ma'am, do you swear or affirm that you will make a true translation of the statements of court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? All right, thank you, ma'am. All right, Mr. Manning, it's my understanding that through what you just stated to me, that Mr. Herrera is asking the court to reset his plea today so he can consult with an immigration attorney.
That's correct, Judge. And as I said, we had set him for a couple weeks reset. He was unable to get in until today at 2 p.m. I did confirm that appointment in the hallway, that he does have an appointment at 2 p.m. this afternoon.
What's the proposed plea going to be?
Judge, it's going to be a plea to assault causing bodily injury, family violence, with a 1245 on the felony. It's going to be for time served and a fine of $1,500.
State any objection? Ms. Viers, are you available on June 2nd or any other interpreter of OCA? Yes, ma'am, thank you.
And Judge, if I may, I am scheduled in Henderson County at 9 a.m., but I can do anything later.
We're trying to set for 11 or something like that. You think that'd be enough time?
That'd be plenty of time, Judge.
June 2nd, around 10:30 or 11. All right, let's, if you would schedule me for 11 a.m. That should be Thursday, yes, ma'am. All right, so Mr. Herrera, the court's going to reset you for June 2nd at 11 a.m. The court is doing this at your request, so you can meet with the attorney regarding your immigration status. So I expect that to be done when you come back on June 2nd. If you come back on June 2nd and you've not done what you told the court you're going to do, then there's a strong likelihood the court will reject your plea.
Okay. Judge, was that 10:30 or 11?
11. So, Mr. Herrera, sign your notice of appearance, and once you get the yellow copy, you're free to go.
Okay, gracias.
You're welcome. Ms. Viers, is there anything? I think that's all we have for you this morning. Is that correct? No, ma'am, unless you want to teach me some Spanish, on recesses. Other than that, we appreciate you, and I appreciate your patience in helping us out. Yes, tell Leonard we said hello. great day.
Little late now. Hopefully, it says it's saved or I just didn't know like I said later.
I believe Mr. Adams is in Hopkins and Russ counties this morning.
Oh, okay, it's just reset.
Right, so I got a notice that state agreed to reset.
I just didn't know why it was set. Just made sure we were meeting each other.
And Mr. Howe, is he going to be here today? Do we know? I'm assuming he's going to come at 11 to get the reset. So, do you know Ms. Abraham? Is Mr. Howe going to be here to get his reset at 11? So don't need to call that one. All right, Mr. Grindel, if you'll come right over here. Right here is fine. Right there. This is a sanctions court hearing. This is cause number CR 19177. Mr. Grindel, as you know, you were placed on probation in this case, deferred probation, on December 19th for a period of 5 years. Court approved your plea agreement on the charge of burglary of habitation, which is a second-degree felony, which carries a range of punishment from 2 years all the way up to the maximum 20 years. And I'm sure I told you that on that day, if you violated any of the terms and conditions of your probation, the state can file a motion to adjudicate your guilt. That means convict you, make you a felon for the rest of your life, and the state could ask this court to sentence you to prison from 2 years to the maximum 20 years. I always explain that, and I explain that to you. I'm confident. Now I've got a document in my hand that says that you're not in compliance with your money, you're not in compliance with your community service, that you're not taking your life skills class, that the probation officers met with you back in September of last year to motivate you to start complying. So you've wasted almost 2.5 years of not doing any of your community service. You have 450 hours you have to do. You've done 0. You're behind 280 hours. In order for you to successfully complete your probation on December 18th of 2024, you would have to work 20 hours a month now. It's set to do 10 hours a month, but you've wasted 2.5 years. And so now you're looking at, you've got to do 20 hours a month. You've got to pay, you haven't been paying either. So now you have to pay $190 a month to probation, $50 to the court. That's $240. You would have to pay that every month and work 20 hours of community service every month, plus paying your restitution and all these things in order to get off on time, because you've waited 2.5 years. So one of two things is going to happen. Either you're going to get revoked and you're going to go to prison, somewhere between 2 to 20. Or you're going to have to get on the ball and get extended if you can't get all of this done. And so you're going to go from 5 years on probation, maybe up to 10 years on probation. A decade of your life on probation, peeing in the cup, doing community service, paying fees. And so I drug test you today. So not only you're not doing your community service, you're not paying, you're not taking your life skills class, you're not taking probation seriously, but you're drinking beer. You're not gonna look at me? And be a man, look at me. I'm looking at you. Okay? Any of that untrue. And I tell you, probation's not easy. I know it's not. But you're the one that said you wanted probation. You're the one that asked me to give it to you, and I gave it to you. And once I give it to you, this is how you treat it. So what am I supposed to do? You mean just tell them, hey, you know what? Go file a motion to revoke. Bring him back in here. We'll get him a lawyer, we'll go through a hearing, prove up, I'll tell the state, you prove up one of these, and I'll just convict him today, and we'll just send him to prison. And you can sit in prison and think about the things that you should have done. I can do that. You want me to do that? So what are you gonna do about it? What do you want me to do?
I was talking with my probation officer in Ocean County, and he threw out the idea of for the community service to get caught up during the first Monday during camp. I plan on getting that situated where I can start doing that each month. And it says that would probably be the easiest and fastest way to get caught up on my probation, on my community service. And then I also have been talking with, I was going to talk to my probation officer this next report and ask him about actually got a job offer for technical drilling. It's a oil field company. See if I would get permission to be able to do that in West Texas.
What about your life skills class? What are you gonna do about that?
I'll give them my probation officer in the next one that's available. I'll get them.
How old are you?
I just turned 22 Monday night.
Just turned 22. You're an adult, aren't you? You're a young adult, but you're still an adult. It's time to man up. It's time to take responsibility for your actions. It's time to face the consequences. No one's going to do it for you. The beer is going to cost you. The beer is going to cost you. This is what it's going to cost you. This is what I always do for people who consume alcohol as a sanction. Is I give you this option, and you can take it or leave it. You'll have to do 3 days in jail as a condition, as a sanction. And I'll let you do that on the weekend so it doesn't mess your job up. Are you working during the week?
Yes,
All right, you working Monday to Friday? All right, I'll let you go in on a Friday night. I'll let you out on a Sunday night, so you can go back to work. That's going to cost you. And if you keep on doing it, it's going to cost you a lot more than 3 days in jail. You're going to be looking at prison time as a young 22-year-old man. You understand? So this is what we're going to have to do. If you want to be successful, you're going to have to pay $190 a month, starting this month, all the way through November of 2024. You're going to have to figure out how to get that done. You're going to have to pay $50 a month towards collections, all the way through November 2024 to get done what you're supposed to get done. You're going to have to do the 20 hours of community service. You're going to have to take life skills. You're going to have to get caught up on your restitution. It's a lot. It's a lot. It can be overwhelming. I know it can. But you're going to have to make a determination. Are you going to do it or are you not going to do it? That means that all of these things have to take priority for you before you decide you're going to go out to eat, you're going to go drink, you're going to go hang out with friends, you're going to sleep in, whatever. Before you make any of those decisions, these have got to be taken care of, because if they're not, you're going to lose your liberty. You're going to lose your freedom. I don't know how to make it more plain to you. Okay? So these are sanctions. You're going to have to do 3 days in jail. You willing to do those? All right, this is what I'm going to do. I'm going to send Mr. Grindel back there. I'm sanctioning him to 3 days in jail on the weekend. Let him pick the weekend that he wants. Friday evening to Sunday evening, whatever times you believe are appropriate for the jail. And then I've told him he's going to have to pay all of these sanctions that are laid out here. If you'll prepare me the sanctions order on that, I'll get that signed. Tell you what I'll do. I'm going to set you out. I'm going to give you 2 months. I want to see progress. All right. I'm going to set you on July 5th. That means there ain't no celebrating with alcohol on July 4th, right? July 4th is Independence Day. you're gonna have your independence restrained a little bit, right? But you're gonna have freedom on July 4th. Don't give that freedom up on July 5th. You understand what I'm saying?
Yes, sir.
Don't drink. Don't do something stupid. Come back on July 5th at 9 a.m. and I want a report from the probation officers that you're getting these things done, that you're on top of it, that they see effort. These probationers are not here to put you in prison. They're not here to make it hard. They're here to help you succeed. So you gotta listen. You gotta do what they tell you to do. You got someone here with you today. Who is this? Your child's mother? I mean, you got one child more? What do you got? 2 kids. How old? 3-year-old and a 1-year-old. They important to you? Love them? You want to be here to take care of them? All right, then it's time to act like it. All right? It would be very unfortunate for her to have to raise 2 kids on her own until you get out of prison. What is she going to tell your kids? Think about it. You don't have to answer me. Just think about it. What is she going to tell your kids? And when you show back up out of prison, they're not even going to know who you are. How sad would that be? They wouldn't even know who their dad is. That's sad to me. It's sad for me to even think about. All right. So I'm giving you this lecture. I'm being hard on you because I want to see you do the right thing. Understand? All right. Go back there and see the officers, and they'll give you your paperwork. Yeah, I'll tell you. I'll fill it out. And I'll send it back there.
Let's go for it.
Ms. Walker, if you'll come forward. This is cause number CR 21312, State of Texas versus Kiana Walker. Ms. Walker, if you will raise your right hand, ma'am, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you may put your hand down.
Yes, sir.
All right, thank you, ma'am. My court reporter's up here. She's got to take down everything we say, okay? All right, Ms. Walker, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Michael Todd. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to discuss your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Todd, do you believe your client to be competent today?
I do, Your Honor.
Have you explained to her all of her legal rights as they pertain to this case?
I have, Your Honor.
You believe she understands them?
I do, Your Honor.
All right, Ms. Walker, I see that you are charged by indictment with a third-degree felony offense of driving while intoxicated, third or more offense. A third-degree felony offense in Texas has a range of punishment of not less than 2 years or more than 10 years in prison and a fine not to exceed $10,000. I see also that the plea agreement you want the court to approve is that you want to plead guilty to that charge in exchange for the state's recommendation that the court assess your punishment at 10 years, the maximum 10 years confinement in prison today, but suspend that sentence and place you on community supervision or probation for 5 years with you paying fines, court costs, restitution, and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
That's what you want the court to approve?
Yes, sir.
All right, Ms. Walker, understanding the plea agreement, understanding the range of punishment. At this time, how do you plead to that offense?
Yes.
Are you pleading guilty to that offense, Ms. Walker, because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, sir.
All right, the court accepts the defendant's plea of guilt. Mr. Todd, any objection to the state's evidence as offered?
No objection, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of Ms. Walker's judicial confession. Anything further from the state? From the defense?
Nope. Well, just the fact that she is on probation, Judge, out of Dallas County also. And so we would ask for the probation to be able to be transferred there. I know that there are outstanding community service hours that she has in Dallas. So I would ask that that would be concurrent with respect to here so she could make those requirements also.
And is there any objection or was that a part of the plea agreement or anything? So Mr. Todd's asking, you're just asking for them to be run concurrent.
Yes.
Are you asking for credit if she does 10 hours of community service? Are you asking that to apply to her Dallas County case and her Van Zandt County case?
Yes.
That agreed to by the state?
Judge, that not previously been discussed, but I don't have the objection specifically in regards to community service hours being included. Obviously for today's condition here will be separate from her Dallas conditions, but generally as a standard of course.
And Mr. Todd. Written on the back of the sentence. Mr. Todd, so if the court does not grant Ms. Walker's request for double credit on community service, is that gonna, is she gonna want to withdraw her plea?
No, Your Honor.
All right, so the court would deny that request for double credit as to community service on two different cases. So I'm not gonna give her credit here for the community service she's doing in Dallas County.
Well, I would understand that as it relates to community service that she has done already, but as it relates to going forward, so we're saying that she wouldn't be able to get credit for both. Well, I mean, if she does 10 hours, let's say next month, if she presents that to Dallas, you're saying she can't present that also here.
What's our policy of this? Say that again.
Service, we put it on the case that's gonna expire first. And then
So if Dallas County case was going to expire first, obviously, well, unless it's a longer term.
It would expire first.
That would apply there. And then when would Banyan County be expected to get community service hours after all of those hours are applied to Dallas County first? What if Dallas County's case was going to expire first and then the amount of community service she's going to do here is going to be large enough for she, let's just say there's a year difference. Y'all want to get together and talk about that?
my opinion is that if I agree with Mr. Todd, she shouldn't get 30 hours credit on the Ramsey County case for what she's already done in Dallas County. But particularly if she is transferring this to Dallas County, she does 10 hours next month. I would say those 10 hours should count towards our case because during the term of probation, she performed those hours. My position is I think she should get credit for 10 hours applied to each of her cases. She did 10 hours that month. But that's, I mean, it's really up to the court, but that's how I would recommend.
And Judge, one of the concerns I had was this, is that when this case occurred here in Van Zandt County, her family made a conscious decision to let her sit in jail for a period of time. So she was down there maybe 2.5, 3 months before bond was posted. She was on probation on the case that was out of Dallas. We took her back to Dallas. We outlined different programs. She's done those programs. She's been working. And so she's in a situation now where she's in a positive manner as far as a positive mode as far as going forward. I just didn't want it to be a situation where, because she has the same amount of hours in Dallas. So she's probably got about 80 hours or so done so far there. I didn't want it to be a situation where we're looking at 700 something hours and then it interferes with work, which then starts interfering with the courses and classes that she's taking, the AA, and then we end up in a spiral where it goes out of control and then we back, drinking or something of that nature. So my request is really, not so much not to stay away from the hours, right? But to also have something that's cumulative, that addresses the issue and allows her to have the time in which to handle all the facets of rehabilitation that she needs.
Well, let me ask. So if she's transferring, she does. All right, so court will grant your request, Mr. Todd, as to the community service hours.
Thank you, Your Honor.
And the rationale that I'm using is if Ms. Walker is going to be required to complete her DWI offender class, she'll get credit for that in Dallas County if that's what was required there.
Yes, sir.
The class would satisfy Dallas County, would satisfy here, as would counseling or anything else.
Yes, sir.
Now, if she doesn't do her community service, I may amend her conditions to make her come do her community service down here, and then she's not going to get credit. She's going to come down to Banton County and do it. So if she's not doing her community service, she's coming up short. I'm going to bring her back, I'm going to amend her, and I'm going to make her come down here and do all of her community service. So right now, she's got a good benefit.
Yes, sir.
She's going to get double credit. She's going to get credit in 2 counties for 1 act of service. So if she falls behind on that, then I'm going to split that. She's going to come down here and she's going to serve this community. She's going to go up there and serve that community.
I understand, Judge.
That makes sense?
Yes, sir.
I think that's fair going forward.
Yes, sir. You understand that, Ms. Walker?
Yes, sir.
All right, Ms. Walker, I have reviewed the evidence. I do find that the evidence is sufficient to convict you of this offense. Court will follow the plea agreement in this case. The court hereby convicts you of driving while intoxicated, 3rd or more offense. The court assesses your punishment at 10 years confinement in the Texas Department of Criminal Justice. The court will suspend that sentence, place you on community supervision for 5 years, order you to pay a $1,500 fine, $60 restitution, $290 court costs, and $35 reimbursement fees. So, Ms. Walker, I've reviewed the evidence here, and I see that you were over 3 times the legal limit on intoxication. And the fact that you were on probation, I don't know what you were on probation in Dallas County for, but Mr. Todd has done you a great service getting you community supervision, I believe. And, you know, this might be something that kept you alive. You're getting arrested here in Banton County at 3 times the legal limit, driving the wrong way on I-20. Could have killed yourself, could have killed any one of us, any other person, any other motorist. So you may be looking at probation as this hampering on your life, but I look at it as maybe it's saving your life. You easily could have hit somebody head on Interstate 20, and you'd be dead. Someone else be dead. And you could be looking at up to 20 years or more in prison. So I hope you realize what you're getting here today, this opportunity to walk out of this courtroom and be on probation. You should be thankful to Mr. Todd for that, thankful to the prosecutors for giving you that opportunity. Understand?
Yes, sir.
If you violate the terms and conditions of your community supervision and you come back to this court and they prove to me that you're not paying, you're not doing your community service, you're drinking alcohol, any violation of any of these conditions, and you're going to be looking at the court just executing the sentence of 10 years, because the sentence is assessed, it's 10. If you violate it, it's 10 years. It's not come back in here and try to work down to 4. It's done. We've assessed 10 years today. Okay, I've done my job. I'll put the ball in your court. It's up to you. Understand?
Yes, sir.
All right, Ms. Walker, you're hereby remanded to the custody of the Banton County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with Deputy McLeish. After that time, report to the probation officers.
Thank you, Judge.
Thank you, Mr. Todd. Good to see you. Mr. Holloway. raise your right hand. Mr. Holloway, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Mr. Holloway, you appeared before this court on October 9th of 2018. You pled guilty to the second-degree felony offense of burglary of a habitation. Court reviewed your case, found that there was enough evidence to convict you. The court followed a plea agreement that you reached with the state on that day. Court did not convict you. Court deferred a finding of guilt, placed you on community supervision for 6 years, ordered you to pay a fine, and ordered you to abide by certain terms and conditions of your community supervision. During your period of community supervision, the state filed a motion to adjudicate, and then they amended that motion on February 11th of 2020. Have you had an opportunity to review that amended motion with your attorney, Mr. Schmidt?
Yes, sir.
Are you pleased with Mr. Schmidt's representation of you?
Yes, Your Honor.
And do you feel like you've had enough time to discuss the case with him, have all your legal questions answered?
Yes, Your Honor.
Mr. Schmidt, does your client waive the formal reading of the state's amended motion? And is it his intention to plead true to all counts? It is. All right, Mr. Holloway. And do you believe him to be competent today, Mr. Schmidt? All right, Mr. Holloway, the state has filed this amended motion, and they have alleged in 5 separate counts, various ways, they are accusing you of violating your community supervision. At this time, I'm going to ask you, Mr. Holloway, how do you plead to counts 1, 2, 3, 4, and 5? Are those counts true or not true?
True.
Are you telling me that those counts are true because in fact it is true? You're not just telling me that so that you can get another plea offer?
No, sir. I'm telling you the fact that it was true.
All right, court will accept the defendant's pleas of truth to each count as alleged in the state's amended motion. Mr. Schmidt, any objection to the state's evidence is offered? No objection. State's evidence is admitted. Court takes judicial notice of the defendant's judicial confession. Anything further from the state? From the defense? All right, so Mr. Schmidt, do you want to speak on behalf of your client, or do you want your client to speak for himself on why the court should put him back on probation when he was put on in October of 18 and then disappeared in June of 2019?
Judge, obviously I have to speak on that. Based on what he's told me, also he's very similar ultimately, Mr. Holloway has set like tragedies in his life that threw him off the rails, including his children's mother. So he's in a state of abuse. Call the court's attention to the fact that Mr. Holloway to get back on track, take care of his needs, stay out of prison. So from that perspective, I believe Mr. Holloway will probably tell you very similar set of circumstances. Maybe more.
Mr. Holloway?
Yes, sir. All the statements were true. I'm not going to deny anything. I lost my children's mother, and shortly after that, my little brother as well. I checked out mentally for a little bit, and that was selfish of me. And I got a lot of time to make up for it.
Tell me what's going on in your life right now that would convince me that you're in a better state to be able to comply with the conditions of probation.
I mean, I'm constantly working. Everything, I'm getting back on track. I don't know, I've been looking into an apartment of my own. I've had a healthy relationship with my roommates as well, taking care of everything. If you looked at me 2018 and you looked at me today, I'm not the same person as I was when I first came up here.
So what's different about you? I understand that you've had some losses in your life, but what's different about you?
I've messed up a lot and learned from it. It took a minute, but
And Mr. Smith said you have kids?
yes, sir. 3-year-old and 4-year-old.
3-year-old and 4-year-old.
Yes, sir.
Are you raising those children?
No, sir, not right now, but I'm in the process of fighting for them. Yes, sir.
Who's raising your children?
They're with their great grandparents right now.
Paying child support, doing everything that you can as a father?
Yes, sir.
So if I give you another shot, you're telling me that you're going to make it?
Most definitely, sir.
You understand you're looking at a big potential prison sentence if you don't?
Yes, sir. Yes, sir.
I know Mr. Smith covered that with you, but you understand 2 to 20 is a big range. And if you got the minimum 2 years, that's a long time to be out of life for the 3 and 4-year-old.
Yes, sir.
Understand that?
Yes, sir.
All right, the court's reviewed the evidence. The court will find that Joseph Garrett Holloway has violated the terms and conditions of his community supervision. The court will follow the plea agreement. The court finds, based on that finding, that his guilt should be adjudicated. The court does adjudicate his guilt, convicts him burglary of a habitation, second-degree felony. Court will assess his punishment at 7 years confinement in the Texas Department of Criminal Justice Institutional Division. Court will suspend that sentence and place him on community supervision for 5 years. Court will order him to pay the balance of his financial obligations. All right, Mr. Holloway, we all get knocked down at some point in our life, sometimes multiple times. And it's not the fact that you get knocked down, it's the fact of what you do after you get knocked down. You get up, you do the right thing, you get back on your feet, or you just stay down. So Mr. Schmidt's telling me that you told me that you've gotten back up. So I'm gonna give you that opportunity. I expect you to be a model probationer, do what you're supposed to do. If you start having struggles, don't stop reporting and run from it. Start talking to your probation officer. They're there to help you, okay? So, all right, I want you to come up here and get fingerprinted. After that time, see Ms. Burns and she'll give you more information.
Judge, I would note that there is an active KPS on this case for Mr. Holloway. So obviously, he needs to be aware that it'll be a minute before that KPS is withdrawn.
Mr. Holloway, I'm going to issue an order to withdraw the warrant that was active for you. It's going to take some time for that to go through the process of being actually withdrawn from the systems. So you need to be careful. So if you get pulled over, the chance that you will be taken in because that warrant can still be out there. So yes, I'll do my part as quickly as I can to be aware of that. Okay. That's all attached there too. Should be 1 second. Hey, Richard. Did Nash Fuller show Yes, sir. All right, the court has called a couple of individuals who are not here. The court has called Keisha Kaufman. The court has also called Nash Fuller. Neither were present at 9 a.m. when their names were called. Bailiff, I've instructed you to call their name loudly, distinctly in the hallway. Any response?
No response, Your Honor.
No response to their name being called loudly, distinctly 3 times. The court will issue judgments nisi and alias capias in each case. The court will take Keisha Kaufman's nisi under advisement until 4 p.m. tomorrow. With that, we are concluding this morning's docket. We will resume at 1:30. Thank you, Mr. White. Thank you, Ms.